Good morning. So did anyone feel like Dorothy last night? It wasn't too bad where I live, but I understand in other parts of the county it was pretty bad. So today is Tuesday, April 2nd. We have 3 cases on the docket this morning. The first case on the docket has submitted on the briefs, and we have 2 that are scheduled for argument. So the first case we have is State of Ohio versus Daniel Littlepage, case number C230368 that has submitted on the briefs. The next case is scheduled for argument if attorneys can identify themselves in the readiness to proceed. Let me call the case first. It's case number C230511, State of Ohio versus James, and help me out with this. Modreski, thank you. Good morning.
Good morning, judges. Phoebe Cates for the City of Cincinnati, the appellant in this matter.
Thank you.
I'm ready to proceed.
Thank you.
Good morning, Chris Degieski on behalf of Mr. Modreski. You're ready to proceed.
Thank you so much. And then the next case we have is cases number C230548 and 549, State of Ohio versus Elena Hammock. If attorneys can please identify themselves in the readiness to proceed.
Your Honor, Jeffrey Kutcher for the defendant appellant, Ms. Hammock, ready to proceed.
Good morning.
And Norma Wessels for the State of Ohio, the appellate, ready to proceed.
Very good. Thank you so much. Good morning, Attorney Cates. How are you doing? Good, good. If you can come on forward. How much time would you like to reserve?
3 minutes, please.
Righty, you can start whenever you're ready.
Thank you. May it please the court, Phoebe Cates for the City of Cincinnati, State of Ohio, the appellant in this matter. Before I begin argument, would the court like a brief recitation of the facts?
We're fine, I believe,
Thank you.
but thank you for asking.
Thank you. The crux of this issue is whether the officers had reasonable basis under the emergency aid exception or the exigent circumstances exception to enter the defendant's apartment. Police officers are duty-bound to provide emergency services to those who are in danger of physical harm. In determining whether someone needs medical attention, the question is, was there an objectively reasonable basis to believe that medical attention was needed? Ironclad proof is not required, and in this case, we know that the officers had a objectively reasonable basis to believe that medical attention was needed.
Counsel, why did the police believe that the infant was in the apartment? What were the facts that caused them to go looking for the child
Yes,
in
Your
that
Honor.
place?
Yes, Your Honor. The circumstances were that the children's services worker, Miss Angel Bell in this case, was on scene doing an after-hours, had received a report after hours to go to this listed location in her brief, in her report. And so it was believed that the child was at this location because of her report, but also because she said in the motion to suppress hearing that she knocked on the door, Mr. Modreski answered it. She said, "Does the mom and the baby live here?" Mr. Modreski answered yes. So that all occurred before the officers had arrived, and Ms. Bell confirmed that information to the officers upon their arrival.
Well,
So-
didn't he also say that they weren't there at the time? Do we factor that statement in at all in assessing what the officers understood about the scene?
Yes, Judge, I think we do, because of what the difference between what Mr. Modreski told Ms. Bell and what he told the officers when they arrived, I think heightens the exigency to get into the apartment, because he's telling Ms. Bell, they live here, and then when the officers answer or knock on the door and are speaking with him through the door, he says, well, they're not here. And at this point, when you have a malnourished child.
Is that an inconsistent statement? They live here versus they're not here?
I believe what the officers thought at the time, based on the testimony given, was that what Ms. Bell conveyed to them was that they believed the child was there because of what he told her versus what they were telling, what he was telling the officers at that time. So in their minds, I think it was not an inconsistent statement, or rather an inconsistent statement being that she lives there, she is here, versus she's not here now. So in their minds, it's inconsistent with what they're receiving from Ms. Bell, because they weren't there for that prior interaction.
Well, wouldn't the starting point for any exigent circumstance involving a medical emergency for a person be that the person is actually at the location? And so it seems like on this record, we have some possible inconsistent information coming from the person on site, which is that, yes, they do in fact live here, but no, they are not present right now. How do we weigh that?
I think we go back to what the officers believed at the time. And so when Ms. Bell is saying, he said that they live here, that I can't speak with them because I won't identify myself because of confidentiality, the conclusion is that they are there, because he's not saying that they're not here, that they live here, but they're not here. What he's told her is that they do live here and you can't speak with them. So in their minds, they don't know whether the child is there or not, and in their minds, they believe that the child is there because of that statement made to Ms. Bell. And in addition, the defendant not communicating that with them, and in fact, hampering their ability to verify that the child is okay. So when you take that into consideration with the fact that Ms. Bell is saying this child has been previously malnourished, deemed failure to thrive, is 9 months old, should weigh 18 pounds, weighs 11 pounds, and needs to be admitted to the hospital.
Was all of that conveyed to the officers?
Yes, Your Honor, it was.
Can I ask a question on like timing?
Yes.
So how, do we know how soon after the child left the hospital that Miss Bell went to the apartment?
We do not know that, Your Honor. Ms. Bell was the after-hours child services worker. I believe at the testimony, she did say that she received her report when she was there and immediately went to the location.
But when, yeah, because I'm just looking, when we're talking about this medical emergency, I think, don't we have to factor in if the child had just left the, like, because I guess the hospital was trying to keep the mother with the child there, right? And the mom left with this malnourished child. And I guess for me, when I'm thinking about emergency circumstances, I kind of wonder, did Miss Bell immediately run over to the apartment that day, or are we talking days later? Because we talk about when can you get a warrant as well, right? So we don't know the timeline here?
We don't know the timeline in terms of hours. We do know that it was that day.
Same day.
Same day. And I would also say that the difference between days versus the singular day and whether it comes down to hours, I don't think would make this not an emergency, because we look at circumstances in which officers are called out. For example, if we had somebody who is suicidal, that could be in a moment, that could be hours, that could be 24 hours. What they know at the time is this person's suicidal, we need to get in. And maybe somebody's keeping us from doing that. There's not time to go get a warrant.
Well, I
because-
understand that. The threshold is whether there's an immediate need. It's not just whether there's a need, right?
That is correct.
So I think that can be considered part of the calculus, because it'll either exhibit the immediacy of the need that warrants bypassing the requirement of a warrant. So ultimately, if you wanted us to really hone down on the facts that bring us to whether it's an immediate need, whether there's the need to protect and preserve life, or to avoid serious injury, what would be those facts that you would ask us to really focus in on?
I would ask the court to focus in on what the officers knew at the time, which is Ms. Bell conveyed to them, this is a 9-month-old baby who's deemed failure to thrive, weighing 11 pounds, should weigh 18, needed to be checked into the hospital, and mother was refusing. And then you have somebody who's not allowing them to facilitate the transport or otherwise help acquire the location of the child.
Was the officers there to do a transport or to do a check?
Judge, that part's not as clear. It was my understanding, based on what Officer Bicknell testified, and I did cite this in my brief, is he said we were there to get child to the hospital. So when he said that, my understanding is that they were there to help facilitate a transport if they were to come into contact with the child. I think their first step would have been to ultimately try and convince mom to help take child to the hospital herself, but if the need be, for them to get involved and transport child. I think that is why the state emphasizes the fact that these officers were called out to the scene, that they had a responsibility, that they couldn't walk away.
That seems inconsistent to the testimony of the social worker, the caseworker involved here, as to what it was that she was seeking to achieve.
Yes, Judge, I do think that there's a difference between what the child services worker was there to do versus what the officers were there to do. I think child services worker was there to convince mom to check in child to the hospital. I think once she called her supervisor, who advised her to call the police were there to see that child got transported to the hospital regardless. And I think that shows a shift in the responsibilities between a child services worker and the police who are called out for this, what they, in their minds, believe to be an emergency. I think the most on-point case is City of Dayton against Johnson. In that case, officers were called out based on a 911 call to a domestic violence situation. They didn't know if necessarily whether somebody's in that apartment, just based on the information they had at the time. And they had to wait over an hour before they were able to get into the apartment. So I think that shows that emergency is an emergency regardless if it's an hour or a minute, and that they were called out there to check on her regardless of somebody at the door saying, no, she's okay. To turn around and get a warrant could have resulted in her harm. So it goes, again, to what the officers believed at the time, given the information that they had. So even though child was not ultimately in the apartment, they believed that she was, and were trying to facilitate that transport.
So this was a suppression motion, and what was suppressed, and why was the state unable to proceed?
What was suppressed was, in defense counsel's motion, they filed a motion to suppress everything that was anything the state sought to introduce at trial on the grounds that it's evidence of an unconstitutional search or seizure. That included the ability to enter the home and any subsequent arrest based on the fact that there was no privilege, and also that there was no probable cause. And the judge just said motion to suppress heard, motion to suppress granted. So the state took that to mean the entirety of defense counsel's motion was granted.
And so the state had no case left
Yes, Your Honor.
because his arrest was suppressed?
Not only because of his arrest, but because the ability to enter the home was not, was also suppressed based on defense counsel's point number 1. So the state could not proceed in the entirety of the obstructing charge nor the arrest charge, and so that's why the state appealed. If there are no further questions, I'll briefly conclude and reserve the rest of the time for rebuttal. Ultimately, the baby's level of malnourishment is not what's at issue, it's the officer's reasonableness. It's reasonable for them to believe that a child who's deemed failure to thrive, had previous malnourishment, and needs admission to the hospital is an emergency. And so regardless of the eventual outcome, what they knew at the time based on Ms. Bell's communication and defendant's communication and actions constituted an emergency. It would be the state's position that officers should not turn around and go get a warrant in this case, but should do everything that they can to ensure that the child is safe. Because malnourishment could mean minutes, it could mean hours, it could mean a day. And that's not something that the state would like officers to guess at.
So where do we draw the line on this? I mean, we're talking about entry into somebody's home. And you want us to say that if there's a reasonable belief that there's somebody, I guess, in distress in the home, no warrant is required. I mean, where's the line here?
Judge, I think the difference is not just somebody who's in distress, but somebody that needs medical attention. And in this case, the child needed medical attention. I think the difference is that medical component, because, for example, if this were a criminal damaging incidents where John Smith damaged my car, and I know that John Smith lives at the appellee's residence, and officers go out there and the appellee's preventing them from investigating, they can turn around and go get a warrant. That's not something that requires them to take somebody to the hospital to ensure safety. It's something that they can go get a warrant and return later. So the medical component, rather than just distress.
It would be life or death medical.
Yes, and I think in this case, it is life or death medical, because this is a child who's 9 months old, and they shouldn't guess at whether the level of malnourishment is warranted to be, oh, it's a couple of days or a couple of hours, we have time to go get a warrant. It's, we need to take action now.
Thank you.
Thank you.
You have your 3 minutes reserved.
Thank you.
Good morning.
Good morning, how are you?
I'm good, how are you? May it please the court, Ms. Cates. So the central inquiry in this case is when there is an official report of a severely underweight failure to thrive child, does that rise to the level of an emergency as contemplated by this exception? And we would point to the fact that there are procedures in place for this very kind of situation. Juvenile Rule 6, the state can institute either before or after an abuse, neglect, dependency proceeding, seize the child after a complaint, or even seize the child first, and there was no testimony elicited to that effect here. The state, actually an easier, quicker route is to obtain an emergency custody order. And that would entail Ms. Bell or the police calling the prosecutor on duty, who's on duty 24/7, them phoning a judge or magistrate, and getting that emergency order without input from the other side. It's actually a relatively quick process.
Or get a search warrant.
Or a search warrant, yes, kind of a similar process, and there was no testimony elicited. This case would have been really simple if the state would have elicited testimony from Ms. Bell or the police saying, yes, that's what we were doing. So I think that
And
this...
those processes could actually have begun at the hospital before the mother left, correct?
Right. So really, it would have been, if the state had focused on that, they wouldn't even need this emergency warrant exception. The whole case would have been disposed of fairly quickly. So, and these procedures are in place.
Counsel, how do we weigh the lack of those processes? Because I think we can make some educated assumptions that the state is not unaware of the tools in its
Right.
toolbox. So how do we weigh the absence of those processes in this case against what the state is claiming to be a medical emergency? Do you understand the nature of my question?
I do, and I think that that's where I was going with this, that it is telling. I think you can presume from the circumstances if they had enough reason to believe if it was imminent danger. Because an emergency order, it's similar to the emergency aid exception, it's imminent danger. I think everyone can concede this child needs help. You know, there's a potential major problem. But the fact that those avenues, those processes were at the state's disposal, we can presume they know about these processes and they didn't use them, which means they probably did not believe there was enough cause to use them. So there wasn't enough. It wasn't enough of an imminent need, an imminent danger to broach the person's Fourth Amendment.
Well, I mean, they sent out a caseworker to check on the child's welfare.
They did.
So
and that's
clearly, they were very concerned
that's
about
step one.
this child.
Yes, and Miss Bell even said, I think they were playing a little fast and loose with transport, where they're the transport. I wanted to correct that part of the state's brief, to transport the child to the hospital. That would have been pursuant to emergency order or an A&D complaint. Ms. Bell testified, I was there to talk, and then convince the mom to bring the child to hospital. In that respect, this case is a lot like the Callaway case. I think it was an 11th District case cited in our brief. That had to do with, yes, an elderly person, but it was adult protective services, like our child protective services, called over because they had concerns. And the officer said, you know, I'm here to talk and see if he's okay. Similar circumstance.
So your argument is that if they truly thought that this was a life or death situation with this child, they wouldn't have just sent somebody over to talk to them, to the mother?
Yes.
They would have
Yes.
done something
I think they would have said, we're here to seize the child.
Right.
And no, this case is really that simple.
The
It
Callaway
elicited that.
case, if I recall that, wasn't the central issue there about privilege?
It was because it was on a sufficiency review.
Right.
So it
was
wasn't a motion to
sufficiency
suppress, so
rule.
it is a
Yeah.
different.
So I understand that the facts are similar, but yet the analysis, the
It's-
outcome was on a whole different thing.
It is different.
Yeah.
They did say that, yes, they did discharge, different lens
Mm-hmm.
of review, yes.
And I understand, I understand your discussion with regard to the tools in the toolbox and what that could mean. But it could also mean other things too, right? So one thing you said at the beginning of your argument caught my attention.
Right.
And what I understood you to say was that the state was arguing today that malnourishment was sufficient for exigent circumstances, that alone establishes exigent circumstances.
Mm-hmm.
Those weren't your words, but that was my understanding of how you started your argument. Okay, can you address that a little
Sure,
further?
so I framed that as really the central inquiry, that if we have an official report of a failure to thrive malnourished child, is that enough to invoke this exception? And we would answer that in this case, at least no, and that's only because the state did not elicit enough testimony. So malnourishment, and I'm no doctor, but you know, there's obviously a spectrum. I don't even know it. You would need some kind of expert testimony. Is this today, the child is dying? Are their vitals down today? We don't know. Or is this the child's,
Underweight.
underweight? It can only mean underweight. I did a brief search, and malnourishment can mean a lot of things.
Well, I think the state has conceded that because they said that it could be a minute or minutes, days, hours, or days.
Right, right. And then we have to guess, even though in closing the state argued it was life or death, we have no evidence, one way or the other, how far along that spectrum was this baby. If the mother left with the baby's vitals tanking, we could be in a different situation here.
Does that contrast this case with, say, cases dealing with something like gunshot wounds or automobile accidents where
Yep.
there may be a much more visible medical emergency?
Right. I think there's certain things we can concede are life or death no matter what. Malnourishment is not necessarily one of them. Again, concerning, yes. But if someone has a gunshot wound to a vital area, like at the torso, and they're bleeding heavily, a layperson could even look at that and say they're going to bleed out. You know, it's the exigency, the immediacy of
Probably
the
a
danger.
gunshot wound to any part of their body.
True, really. But I think the immediacy of that danger is much more evident than a malnourished child. And I agree that we don't, the police aren't doctors, the police need a lot of leeway too. I get that. But in the future, the phone call to the prosecutor or to the magistrate is not that hard. In that instant, they can do it. And then the police in this case, the body cam I think is very valuable in, I like to say that them forcibly breaching the residence and then testifying to the opposite on direct, by the way, this is exclusionary rule type of behavior. You can't just do this. So it really is a delicate balancing, but I don't think this court needs to issue bad precedent. Confining this to the facts, there wasn't enough elicited here that this was an immediate need. It's really that
And while
simple.
it doesn't go into the calculus of the officer, in this case, wasn't the child and the mother, in fact, not in the residence and were
Correct.
actually at the hospital at the time?
They were by the
this was
time it wrapped
occurring?
up, yes. And you had asked the state about that, and it wasn't contradictory. I looked back over the transcript. He did say, yes, they live here. And then he never said they're home. And in fact, a little bit later, he said Jade is not here. That's the mother, his daughter, the mother of the child. So, and then we find out at the end, oh, they're back. They're at the hospital anyway. So, but really, we don't need to get that far. I think this is a clean-cut case. The trial court got
But
it right.
that doesn't go into the calculus because it's really what would they have known and what would a reasonable
Yeah.
officer have done.
Yes, yes. If there are no further questions, we just ask that this court affirm the trial court's decision granting the motion to suppress.
All right.
Okay, thank you.
Let me make sure, are there any other questions from the panel?
Okay.
Thank you.
Thank you.
Just briefly in response, I think opposing counsel's point about there not being enough testimony about the malnourishment, the extent of it from a medical expert strengthens the state's position that the officers were not able to turn their backs and walk away. They didn't know the extent of the malnourishment, but what they did know is that the words failure to thrive, admission to the hospital, previous malnourishment were being used. And a reasonable officer in that situation would find that that's an emergency. This isn't just a case of malnourishment. This is a case of needing to be admitted to the hospital. And so that,
And they also knew there was a baby, right?
Yes.
And they knew the approximate age of the baby,
yes,
too.
they knew the child was
It was
9
an
months.
infant.
Yes, Your Honor. So I think that strengthens the state's point that officers are not in the position to guess as to the level of the malnourishment, only that they are being told this by Ms. Bell. I also did want to clarify, counsel had mentioned the officer testifying to the opposite on direct about entry into the home. They never said that the neighbor permitted them to enter the home. They just said that they made their way into the home. And I don't believe that's an inconsistent statement that should be taken into his credibility. Additionally, the contradiction that comes to what the officers knew at the time was, yes, they live here, no, you can't speak with them. And then when they arrive on scene, she's not here. And now that the police are involved, what's being said is she's not here. So there's no, what the officers could have known at the time was that maybe that was motive, maybe that's to prevent them from investigating a case of neglect or abuse. So we ask that you would overrule the trial court's decision and reverse the motion to suppress. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. I wish you a dry, wonderful afternoon. Thank you. State v. Hammock. Good morning.
Good morning, Your Honor.
How are you doing?
Good, thank you.
Would you like to reserve time?
3 minutes, please.
All right. I think I hear some rumblings. Do you hear them?
I'm sorry, you
Do you
thought
hear
you
the
heard?
rumbling?
Oh, I did not.
Yeah. I think we're getting a storm coming in. All right, you can start whenever you're ready.
Thank you. May it please the court, opposing counsel, Mr. Wessels. Jeffrey Kutcher for the defendant appellant, Ms. Hammock. We're here asking the court to vacate 2 convictions, that for criminal trespass and obstructing official business. Our expectation is with the state's concession to the criminal trespass that we're here just to talk about obstructing official business. But briefly, the criminal trespass is simply, the proof is at trial that Ms. Hammock owned the property, she's on her property, she's not on that of another.
And the state has conceded.
Thank you.
Okay.
As to obstructing official business, of course, we have the statute, 2921.31, but we look for a little bit more detail in the analysis, and we find that from several decisions, but the recent decision we focused on, the more recent from 2022 case with a 2023 cite is in Ray S.J. And there we're told that the defendant must perform an affirmative act without privilege, with purpose to obstruct, delay, prevent the performance of a public official. And that act had to actually hamper or impede the public official. And what we think is key is that hampering or impediment must be more than de minimis. And we're kind of uniquely positioned now with technology and the body camera. The crime or the lack of crime here, we think, is fully on the police body camera that was admitted as State's Exhibit 1. And so we start with the performance of an act and note that failure to act is not an act at all. And so when the officers arrive and we acknowledge there's a statement by the officer that he has some sort of warrant, but we think the body camera also shows at the same time a distressed Miss Hammock inside her home behind a locked door who never unlocked that door. And so first, that failure to unlock the door, the failure to act, we don't think is any affirmative act at all. There's testimony at trial.
So even if the door is broken down and, you know, and that's all that happens, in that case, there would not be an obstructing official business, is what you're saying?
That's what we think.
Okay.
We think the police could have arrived with a battering ram, and hopefully they would have chosen a door. They were at the side door here. Hopefully they would have chosen one that they knew Miss Hammock wasn't right behind.
Sure.
But certainly they could have used that battering ram to go inside, and the failure to let them in would not have been an affirmative act.
Counsel, I think your opponent is going to argue that she was outside and then she went back inside and shut the door, and that it was that act of closing the door and locking it that created an obstacle for them entering the home. How would you respond to that constituting an affirmative act?
I would respond with the preface, with all due respect, I don't think he's going to argue that, because I know he watched the body camera. And I know that there was testimony from the officer that Miss Hammock was outside and she ran inside and she locked the door. But that's completely unsupported by the body camera. We think that at trial, the officers had been to Miss Hammock's house probably several times, but at least twice, in July for obstructing, in August when I think they were serving that obstructing warrant, and
Yeah, they
also
seem to have
charged
a
her.
process that involved a trash can,
Right. And so.
that the officer was intending to employ.
Right. We think he was mistaken on the date in question. She actually did not run inside. Had she, I think I'd have to concede that that's an affirmative act.
So it's established that the body cam, the officer didn't say, well, that happened, but it didn't get captured on the body cam.
I don't think that's the testimony.
Okay.
I want to make sure, I'm not sure that I fully understood you, so I just want to make sure. Are you saying that she never stepped outside of the door?
That's correct.
That's what the footage shows, that she never stepped outside of the door?
That's correct. The July 28 footage shows she was always behind a locked door. She never stepped outside. Yes, so we'll move on from that.
Okay, I mean, the body cam speaks for itself.
It absolutely does. And so on the front end, no affirmative act because she didn't unlock the door. The police, I can hear him on his body camera. He says something about a search warrant. But when he's talking or yelling at Miss Hammock, it's a side door of the home. There's a small deck. There's 5 or 6 steps, I think, that
Let me
go.
re-ask that question.
Yes.
Are you saying that she never opened the door?
She never opened the door.
To any extent, that door was never open, always was locked and so fully ajar?
The Norwood Fire Department pried that door open, and I'll get there. And I'll get there right now, since that's the interest of the court. So she doesn't open the door. So the police asked the Norwood Fire Department with what I think they call a Halligan bar, Halligan. It's in the transcript. It's on the body camera as well. It's a big pry bar. And they do manage to get the door open a couple inches. They've got that pry bar in at the latch, and it takes a little effort, but they get that door open a couple inches. And somehow, I concede in my brief, I don't know how, but after that's opened at the latch, Miss Hammock appears to get the door shut and relock the door.
And how is that not an affirmative act when she pushes the door back closed?
Well, I'm afraid that might be an affirmative act. In fact, I may concede that that's an affirmative act. But I
Okay,
think,
so we've got that element. So
Okay.
then what about the other ones?
well, thank you. I think that element works in conjunction with privilege. And so this is where I'm trying to
Well,
explain.
how would she have privilege? I mean, they have a search warrant at this point, right?
They do, but does she know that they have a search warrant? Is she mistaken in fact, and she doesn't know they have a
The
search
videos,
warrant?
you do agree that the video speaks for itself.
I do,
And I actually wrote notes on what I heard on the video.
okay.
And what I heard was the officers say, I have paperwork for you. We have a search warrant to search the property, Elena. I need you to come outside. And then she said something, and the officer replied with, this is your copy. And she said, what are you searching for? And he said, what? He said, we have a search. We have to search the property to make sure it is safe for you to live here. And then she said, I do not want any of you here. These are my notes and what I heard on the video.
Okay, and what I want the court to at least consider is where he was when he was yelling that or announcing that, and what Miss Hammock was doing at the time. My recollection is Miss Hammock's got two phones. She's videotaping the police with one phone. She's on the other phone claiming to somebody that
So
the
you're
nor-
saying that she didn't hear him?
that's
Is that your argument?
my argument is she didn't understand them.
Okay.
She would have heard them say something, but she didn't understand that that was a lawful search warrant.
This is a credibility issue because you're saying she doesn't understand or didn't hear, and then clearly the officer told her there was a search warrant.
Yes,
So
but
what is there in
again,
the record to support that she did not understand it?
is there anything in the record that
Yeah.
supports that? But her actions. She's on a phone, theoretically with 911, I don't know with whom, but saying that the police are there breaking into her home. And I just want to get this
But
out.
They were there. breaking
They
into
were
it.
there to break into
They
her
were
home
breaking into her
lawfully.
home.
I totally understand that. But did Miss Hammock understand that when the police, from the bottom of the steps, up 5 or 6 steps to a landing, and then turn right, and she's behind a locked door, kind of hysterical, did she actually understand?
But wouldn't that actually support the state's case in that her purpose appears to be to stop the police from coming in? And that's their actual legitimate purpose for being there, is to come into the property, and she wants to stop it. And I can appreciate what you're saying, that she didn't fully understand maybe exactly the whole dynamics of the situation, and I'm sure she felt stressed and scared. I'm sure she did. But all of that suggests to me that her purpose was actually to stop the officers, and that's what the obstruction statute gets to.
And I just want to respond with, her purpose was absolutely to keep those police and public officials out of her home. But I'm back to Your Honor's inquiry or acknowledgement that she just may not have understood that there was a lawful search warrant. I think the police officer could have left it on the landing, tucked it between the doorknobs, something. My recollection is he was always from the bottom of the steps yelling at her through the closed door.
But she didn't testify at the suppression hearing that she didn't understand or hear it, right?
Well, no suppression hearing, but at trial,
I mean, at
she did
trial.
she did not testify. But let's not hold that against the defendant, because we can't hold that against the defendant, their failure to testify.
Understood.
So let's arguendo. Let's say there was that affirmative act of her relocking the door, okay? And that relocking was with purpose to prevent absolutely those public officials coming in.
Well, can I add something to that?
Absolutely.
What I saw in the video was that there was a sort of like a pushing match that took place between the officer and her, which the reason I raise that is because then that brings me to the case Easterling.
There was some testimony, I wouldn't call it a pushing match, but in trying to get the door open, there was some testimony about the mountains of clutter. And I think it's a question, and maybe the only question that's not clearly visible from the body camera, was there some mountain of clutter or something behind her that prevented her from backing up? Miss Hammock, I think you'll see from the video, is not going to win a pushing match with the Norwood Fire Department or their Halligan bar. But somehow she does get that door closed after it's opened. So if the court will not agree with me or entertain that works in conjunction with privilege, and because maybe she didn't understand there was a lawful search warrant, that doesn't matter, okay? Then I want to get to the last prong that,
Well, I think it can matter. The question is, what does the record show, and whether it supports that, and was there a credibility determination that was made?
yes, ma'am. And
So all your arguments are well taken.
Thank you.
We have to look at it from the perspective of the record, and I think we can all agree that the video speaks for itself.
Totally understood. And so I want to get to that affirmative act that she did do in relocking the door, if not something else, even if there was a pushing match, whatever it was. Her affirmative act, did it cause a delay that was more than de minimis under the circumstances? And I argue no, because after she gets that door relocked, the Norwood Fire Department basically immediately gets that door reopened, and now we're done.
And I understand. I think that's where I would bring Easterling back, talking about this pushing match with the door. And in this case, you have the reclosing, the locking, the pushing match. You have even more than you have in Easterling.
So you're arguing that we would, to determine de minimis, we look at the first of the affirmative act, which is pushing the door,
That's what I think.
and then the whatever, how many seconds between that and the door coming back open.
Which is very, very quick, very
Okay.
short period of time. I know that the state mentions in their brief a total timeline of about 20 minutes. I would even argue that this whole situation that maybe took 20 minutes, I mean, if it takes you 20 minutes to get into somebody's home, that might be de minimis under the circumstances, but,
How long would it have taken them if she were not there?
well, I don't know what they would have done. If she was not, the whole purpose was to get her out of the house. So if she was.
The whole purpose was to execute a search warrant. They were there to execute a search warrant.
Well, it was an administrative search warrant. I'm not certain that they were actually searching for anything. The search warrant was not introduced as evidence at the trial. I even mentioned in my brief that maybe it wasn't even valid, but that wasn't brought up at trial, so we can't go there now.
I appreciate that.
Yeah, but an administrative search warrant, I think the only purpose was to get her out of this home that had been determined by the city of Norwood to not be inhabitable. And so if she wasn't there, they may have just put plywood over the door and the window, which they later did, to try to prevent re-entry.
So
They
the
were trying
search,
to talk her out of the home.
They were trying to talk her out of the home. Yes.
the
Yes.
search was for her?
That's what I believe. Of course, it's not in evidence, but I believe when they talk about administrative search warrant, the search, the administrative part of it was get all occupants out of the home, and her and whoever else. So not necessarily just for her, just the occupants of the home.
So in that case, would it be typical that people would take a long time to come out of their homes or to abandon these kinds of properties? I mean, would this be the typical kind of interaction that would occur in these administrative search warrants, getting to the hampering and impeding? I mean, do we have any evidence of how long it normally takes officers in these kind of situations?
I don't have experience with it. We certainly don't have any testimony elicited at trial. In theory, if she's being put out of her home forever because it's not inhabitable, then she'd want to gather a whole bunch of belongings, and those police are going to be on the scene for a little while. Of course, I guess the administrative search warrant probably says, hey, this place is so dangerous, leave your stuff in there, we'll deal with it later, get out now. So I don't really know. But in the end, concession that however she relocked that door, that's the affirmative act. Please look at that in conjunction with privilege if you'll agree with me that she didn't fully understand what was going on or that this was a lawful search. And please find that that act is de minimis in that the fire department and then the police gained entry immediately after.
But as you said, your entire case really hinges on this de minimis argument. I mean,
It does now. I kind of liked the privilege thing a little bit more walking in here, but I think,
that's a tough one, though.
yeah,
That's a tough one. I mean, I do think your de minimis argument is interesting. I don't know if it carries the day under the law, but it's an interesting argument. You're arguing that it was mere seconds because we don't look at the rest of the time involved
correct.
in getting her out of the house, is what you're arguing.
Correct, because everything else is not an affirmative act. It's a failure to act. And it's not just de minimis, but de minimis under the circumstances. And I think the proof here is that they've dealt with Ms. Hammock several times. They know it's going to be a long procedure. Thank you.
Thank you, thank you, and I am reserving your 3 minutes.
Thank you.
All right? Good morning.
Good morning.
Shall we just get to de minimis, or is there something else you want to talk about?
We can get to de minimis, Your Honor. I think in order to get to de minimis, that element of it, one of the important things will be to do is to determine the time frame of, like, what exactly is the time that we have to consider as de
And
minimis.
can I ask you a question, and it was one of the last things articulated. Is it de minimis under the circumstances that we should be looking at?
I think one of the things that this court has said, more specifically in recent years, is that the court is supposed to focus on is on the actor's conduct and the effect that the conduct has on the public official. And so in that sense, it seems as though the suggestion is that it's the circumstances in totality, not just looking at it from the perspective of just a simple time determination. I mean, there have been courts in Ohio that have determined that 30 seconds is not de minimis. This court specifically has determined that 1 minute and 40 seconds is not de minimis, but then just recently in 2024, this court has said that maybe 20 seconds is de minimis. So I don't think it's necessarily just a determination of time as much as it is the conduct and the effect that it had on the public official attempting to go about their duties. And in this case, as the officer testified to, they had to get 3 officers that had to force open the door. They had to get the fire squad out with a Halleck bar in order to pry that door open.
Well, their argument is that she wasn't taking any affirmative act. They're arguing she had not committed any obstruction at that point, and so all of those duties would have been undertaken anyway because there was no criminality at that point.
And that's what I was going to get to when I was talking about the time framing of the de minimis and where we start our determination of an overt act. And I think the whole court has conceded that the video will speak for itself. My review of the video is that and this is, I think, the important determination here is there's not just one door that's involved here. There's 2 doors. There's a storm door that opens up that has some sort of plastic tearaway mesh over it, and then there's the actual door. My review of the body-worn camera, and the court can review State's Exhibit 1 for itself, is that you can actually see Miss Hammock open up that inside door and stand behind the storm door when she's talking to police. The police clearly, I think what's indicated on the body-worn camera, have a system of talking to her. They indicate that they don't want to be standing on the porch when she opens the door.
There seems to be some concern of the safety of the porch and an officer's hesitancy.
Which is the reason.
Coming upon the porch.
Correct, which is one of the reasons, I think, for the administrative search warrant in the first place, the safety of the home. But what I can see, there's 2 things that opposing counsel said, was that she's always behind a locked door and she never steps outside. I think she never steps outside is a correct statement. I don't think it's fair to say that she's always behind a locked door. In fact, you can see her open the door and she's talking with officers while they're explaining to her. And the door is actually open when, as the court has indicated, they indicate to her that they have a search warrant. They're showing her the search warrant, and they're trying to go through a system whereby she can come out and get the search warrant because they've had this past history with her. So my suggestion would be that the act of, once she has opened that door, once they have informed her that they have a search warrant and that their intention is to search the home to effect that search warrant, and she closes the door, and not just closing the door, but locks the door, That is the overt act that the court should look at for the purposes of determining the obstruction, because it's after that point, and you can see the officer go up and check the door and says, believe what he says is she locked it. I know one of the things that opposing counsel mentioned is whether or not they could have shown up with a battering ram and just battered the door down. It's fairly substantial to a case that they cite in their brief called State v. Crawford, which was decided by the 2nd District. In that case, they actually determined that not the locking of, but the mere shutting of the door still constitutes an overt act. Now, in that case, they ultimately determined that the obstruction was de minimis because the door was never locked, and they didn't even check to see if the door was locked. As soon as the door was closed, and I mean as soon as the door was closed, they went up and they battered the door down
So the
without
two of you
checking.
have a very different view of the video as far as what happened.
That's correct.
Okay, so what you're saying is that she wasn't just standing behind a locked door. She was behind a glass storm door.
Correct.
Door. They showed her the warrant, and then she shut the other door.
Correct, and locked the door. Obviously,
And
the
locked
door
it.
would have to be unlocked for her to come out of it the first time.
Okay.
Even so, and again, I talked at the beginning about talking about the whole of the conduct. In addition to what I believe the video shows is her closing and locking that door the first time, you can see when they get the Halleck bar and they pry it open. So now we're dealing with 2 doors and now 2 locks. I think this is the explanation that the video shows in terms of how she was able to get that door locked. What I believe shows, and I think it's corroborated by what the officer says on the body-worn camera, they first take the Halleck bar and they attempt to pry open the actual doorknob. And so the doorknob not being activated, and you can see the officer try to jiggle the knob, it doesn't turn. With that knob not turning, it's actually that knob, the mechanism that's keeping the door closed. After they pry that open, she pushes the door closed and locks the deadbolt. And so you see they have to reposition the Halleck bar up over towards the deadbolt and pry the deadbolt open in order to get into the door. And then after that, once there's no more mechanism that's preventing the door from being closed, there's a pushing match that ensues between Ms. Hammock and the officers who were present at that time. And I think it's been suggested that maybe there can be other reasonable interpretations. Perhaps there's clutter that's keeping the door open. And I'll admit, you can see clutter inside the door, but ultimately that's a determination for the trier of fact. And I believe that this court, if the court believes there's some sort of inconsistency, should give the interpretation that is consistent with the judgment that the trial court rendered below.
How long should this encounter have taken in a perfect world?
I don't have an answer for the court, as I don't know the usual circumstances. One thing that Your Honor asked was about, I believe it was how long this normally takes or how long something like this should normally take. I don't know if that's the determination that the court should be looking at. The requirement for OOB is that it hampered the performance of the duties. It's not simply that it now takes longer. It's that they did an affirmative act that was intended to and actually did hamper them. So even if they were still able to effectuate the search warrant within the normal amount of time, let's say that this was even a quicker search than they normally do because they have some experience with Hammock, they knew what they were going to do. And on this circumstances, compared to all the myriad of other administrative search warrants, this took less time than normal. I still think that an OOB determination would be appropriate here because, again, we have the overt act. She has no privilege to do so. She purposefully, I think, which is indicated by, as the court has already referenced, what she says to officers. I think the purpose is there, and I do believe it hampered the performance then beyond a de minimis requirement.
Point taken, but time is one way we could look at hampering. I assume like level of resource commitment or something would be some other way we could look at hampering.
Sure.
What is the hampering here?
I think, assuming, of course, as I am, that the hampering begins at the time where she closes and locks the door. I would have to look at my notes, but I believe that happens somewhere around 4 or 5 minutes. It's around 17 minutes by the time that they actually have the officers in the Halleck bar there in order to open up the door. From that point into the point where they're actually able to get into the house, it's another, I think, 6 or 7 minutes. So that amount of time in connection with the as the court said, the resources that had to be allocated were what I believe hampered. And this is all in connection with, as I've said, the overt act, with the purpose of which is to keep them from effectuating that search warrant. I think that the officers tried to go about this in a way that was safe and in consideration of the circumstances that they had previously with Ms. Hammock. I think that's indicated by the body-worn camera and the testimony. But this is not a case where we have someone who's simply failing to cooperate with a search warrant. This is someone who, I think, as the trial court indicated in its decision, actively attempted to hamper the effecting of that search warrant. There was some discussion about privilege and purpose. It seemed to me as though defense counsel was conceding that that was her purpose, although suggested that she may have had some sort of privilege or that she did not know. I think that's flatly contradicted by what she says. She indicates that she understands, as the court indicated, she asks, what are you searching for? She obviously heard that they had a search warrant and they were attempting to effectuate that.
She responded with, I don't want you to
Correct.
be here. Something to that effect, yeah.
So with those, I guess in terms of what I would, just in some of the things that I've referenced to the court, that this court has determined that 1 minute, 45 seconds, 1 minute, 40 seconds, as far as time is concerned, is substantial enough to overcome that de minimis. I referenced another case that was decided by the 11th District where they determined that 35 seconds. In terms of this overt act, as I've already indicated, the 2nd District has determined that simply shutting the door is an overt act. To me, when it comes to an act designed to hamper the police in effectuating a search warrant, to me it would seem the quintessential act would be locking the door and preventing them from doing so. It's an act purely designed to obstruct someone from entering the home, just by the very nature of it. Unless the court has any other further questions about anything, we would simply ask that this court affirm the trial court's decision.
Thank you.
Well, the last thing I want to do, Your Honors, is misrepresent to the court. And so my focus is certainly on what sounds from Mr. Wessels to be the second overt act. But what I'm wondering now, and I don't have the notes to support it, other than to say, obviously, the video speaks for itself. If that door was open and Ms. Hammock yelled something out, I wonder if that's before the announcement of a search warrant. I don't know, but I really have no more to say about it, other than I know you'll watch the video.
Well, I mean, I've written exact notes of what took place, so she asked, what are you searching for? They say, that the officer says, we have to search the property to make sure it is safe for you to live here. She responds, I do not want any of you in here.
So her question, what are you searching for? I don't know that that's really answered. I mean, I hear you, that we're searching to make sure it's, I don't think they're really searching to make sure it's habitable. I think there's already a determination that it's not habitable, and that's why the search warrant is there to remove her from the home. They're certainly not there to arrest her for anything. If she's not there, the door should be locked anyhow, and they're going to have to break in anyhow. And so, yeah, our whole argument is about the de minimis nature under the circumstances, those circumstances being, oh, by the way, the police called for the UC Mobile Crisis Unit to come speak with her. Her hysterical nature in the video that looked like she was taking, plus the claim that I have to assume is true in her head, that the police are there breaking in because despite the officer saying, we're here to search to make sure it's habitable or whatever he says, I just don't think that resonates with Ms. Hammock. So we'll submit on the de minimis nature under the circumstances.
Thank you.
Thank you.
Really appreciate both of your arguments this morning. We understand the situation that each one of you are in. Thank you so much, and we will take the matter under submission and issue a timely decision. And if I can have a moment just to gather my paperwork. Wish you both a wonderful afternoon, and that concludes the hearings for this morning.
Thank you. Take care.
Court of Appeals, First Appellate District of Ohio is now adjourned.